Hello, this is Scott Horton. We have just launched today's webinar, so attendees will be able to start joining the room. We will be getting started as scheduled in about 5 minutes, but we have opened the room to allow the attendees to start joining. To join, you should see the cover slide for today's presentation, the Fall 2021 New York Employment Law Update. If you can see that and you can hear me and also have access to the chat window where you'll be able to ask questions, then you should be all set. You just need to sit tight until we get started with the presentation. Thanks to all of you for joining. We will get started in a few minutes. We just need to allow time for everyone to get into the webinar. It's going to hop in every so often here just so that the people that are joining can make sure their audio is working. So again, my name is Scott Horton. I will be presenting today's webinar. We are still having a good number of people join us gradually, so we'll wait a couple more minutes and then we will get started as scheduled. We'll go over some details right when we formally begin the presentation, but just for those who are joining, we will aim for this presentation to last about an hour. We will take questions at the end. You can type those into chat throughout the presentation, but I will stay on at the end to answer all the questions that come in. Something else I'll say again at the beginning is that you will get access to the slides for this presentation at the end of the presentation. And if you're registered, they will also be emailed to you tomorrow. Get started in about 1 minute. Again, I just want to keep hopping on the audio so that the new attendees who join can make sure that everything is working properly for them. Hopefully you can see the slides for the presentation. The cover slide is up now, Fall 2021 New York Employment Law Update, and you have access to the chat window where you will be able to ask questions. Okay, we are now at the scheduled start time, so I will go ahead and make the introductory comments about logistics as a few more people may be joining us. But again, my name is Scott Horton. I am the founder and attorney with Horton Law PLLC in Orchard Park, New York. My presentation today is going to touch several topics, and We're calling it the Fall 2021 New York Employment Law Update. A wild ride continues. When I scheduled this presentation, there are a couple of topics that I was hoping to have more detailed information on based on some deadlines and recent events, but we do not have all of that information yet. But nonetheless, we do have several different topics to discuss and the status of some of those COVID related issues. So my introduction includes restating that we will probably go for about an hour. I will stay on to answer any questions at the end. Please type those in the chat window as you have them so you don't forget. If I happen to see a question as I am discussing the topic and can fit the answer in seamlessly enough, then I'll try to do that. Otherwise, we will mostly answer the questions at the end. I will stay on to answer the questions as long as necessary to get through them, but try to finish up all of the material in an hour or less for those of you who need to move on with your day. If you have any technical problems hearing the audio or seeing the slides, then I suggest maybe you try re-entering. Other options include making sure you shut down some of the other things that are running on your computer. They may be taking up resources and slowing down the webinar. But generally, people haven't had too many problems. You will also get a copy of the slides. It will be made available for you to click through and download at the end of the presentation. And if you're registered, you will also get an email tomorrow following up, confirming your attendance and linking you to the slides. With that, I am going to go ahead with the presentation. Here are generally the topics that I want to highlight, although we may touch on a few other issues as we go. First, there have been announced minimum wage increases for New York. As you probably all know at this point, the minimum wage in New York is now based on which part of the state you are in. New York City, for the most part, has had its wage increases capped out at this point, so there are no increases there. However, other parts of the state, including all of upstate New York, which is most of the state based on geographic area, do have new minimum wages coming into effect at the end of the year. And technically, it's not just the hourly minimum wage that has increased. There are some other dollar amounts, including the exemption salary threshold, that are affected in parts of the state. So we will be talking about that in today's presentation. When I gave my spring employment law update, one of the hot topics was the new state marijuana legalization and the impact of that on the workplace and your workforces. We discussed that back then. The reason it's back on the agenda for today is that the New York State Department of Labor recently put out some frequently asked question guidance on the issue for employees and employers in New York State. So I want to give you the updates on those frequently asked questions. You will see in parts of this presentation that the slides are somewhat lengthy and have some detailed information on it. We may not go into all the detail on some of that, but I just wanted you to have the information together in the slides if you keep them for future reference. So there will be some quote unquote old material in addition to the update information, but I just want you to have it for reference. One of the big issues that I was hoping to have even more information on at this point is the workplace safety committees, as will be part of New York labor law beginning November 1st. Obviously, that's only a few days away. The New York Department of Labor needs to issue guidance to address various complexities about this new law that came under the HERO Act. And unfortunately, as of The last time I checked a few minutes ago, they have not issued that guidance yet. So we will talk about the law itself, what looks like will be required beginning next week, and then what we expect to see yet from the Department of Labor. Another issue that is still evolving relates to vaccine mandates. Some of you in your organizations have mandated employees to become vaccinated or will be doing so. In some industries, it may be because you're required to, healthcare in particular, to a slightly lesser or different extent. If you are with a school district, you may have a vaccine requirement, although in that case, there's also the option to test weekly. But the biggest issue that we're waiting to see develop is the federal OSHA rule that is supposed to require all employers with 100 or more employees to have a vaccine mandate for their employees. The expectation, based on what the president directed OSHA to do, is that that mandate would also have a weekly testing opt out type of alternative. In place now is guidance for federal contractors. So if your company has contracts with the federal government or with you're a subcontractor for a contractor of the federal government, then in the near future, you will likely become subject to vaccine mandates based on those contracts. We have relatively new information on that since our last webinar last month. So I will be discussing that as well. And also in the area of vaccine mandates, yesterday, the EEOC came out with new guidance on religious accommodation exemptions, I guess you will, for vaccine mandates. So we will be discussing that issue as well, which I know has come up in many workplaces. And I have spoken to people about the difficulties in dealing with that. But we do have new word as of yesterday from the EEOC, and we'll talk about whether that helps any of you or not. So the first couple topics are really New York law. So that's why I have this slide. Toward the end of the presentation, we'll get to the federal level information. But for all of this, I will mostly be talking about it as relates to employers and their employees within the boundaries of New York State. If you have employees outside of New York State, most of the New York requirements will not apply to them, but the federal requirements may apply to that. Yeah, there's a question. If you entered late, yes, the slides will be available at the end and will be emailed out to you tomorrow as long as you're registered. So going on to the minimum wage issue, over the past few years, New York State has implemented the regional or geographic, if you will, distinctions in the minimum wage on the theory that New York City employers could afford to pay more than some upstate employers. But the goal was to phase it all up with a target of $15 an hour with increments over the past several years. As of the end of 2020, so already in place for this year, all of New York State had hit the all of New York City had hit the $15 hourly minimum wage. At this point, there is no change in New York City taking effect for next year. The changes are for Long Island and Westchester employees, and their minimum wage will now get to that $15 an hour amount. And the remainder of New York State will also have an increase in its minimum wage from $12.50 to $13.20. Just a reminder that for whatever reason, the state has made it over the past several years such that these minimum wage increases actually take effect on December 31st rather than December 1st. I don't know whether there was a really good reason for that, but that is the way it has been. Now, that increase in the minimum wage was widely reported and announced. What hasn't been widely reported and announced, and you may not be able to even find it on the New York State Department of Labor's website even yet at this point, is that by virtue of the increase in the minimum wage, other amounts in the minimum wage and overtime requirements of New York law also automatically increased. So in Long Island and Westchester and the remainder of New York State, there will be a higher salary threshold for the overtime exemptions. Specifically, this is the administrative and executive exemptions in New York State. So in Long Island and Westchester, that amount will increase to $1,125. And for the remainder of New York State, the salary requirement will increase from $937.50 to $990. So again, if you have employees who are exempt under the administrative or executive exemption in these parts of the state, there will now be the requirement that they meet this new threshold. The professional exemption in New York doesn't have a salary requirement. So if you have accountants, doctors, lawyers, teachers working for you, for example, and other professionals as well, then they will not have to have an increase to maintain that exemption. They still need to meet any federal FLSA requirement, but that's lower than these New York State amounts. Or in the case of doctors, teachers, and lawyers, there is no salary requirement either under state or federal law. But for many exempt employees under the administrative and executive exemptions, you will now need to raise their pay to at least $990 a week for them to still be exempt beginning December 31st of 2021. I don't have slides on it, but there are a few other aspects of the minimum wage laws that automatically increase as well. For example, in the hospitality industry, restaurant workers, their tip allowances outside of New York State are now different. They need to receive a higher cash wage per hour, and the other types of changes affect certain allowances, uniform requirements. So some of those issues where there are legal dollar amounts attached related to minimum wage and overtime laws, there might also be an incremental increase. Now, turning to the marijuana issue, as I said, most of this was discussed in more detail in my spring employment law update. So, not that I'm not happy to discuss it again, but we just want to, focus on the newest information. So, by just brief background, the marijuana, sorry, I'm trying to remember the name of the statute again. The Marijuana Regulation and Taxation Act. It's not MHRT. It should be the MRTA. But nonetheless, that law was signed and took effect immediately in some respects in March of this year. It legalized recreational marijuana use with some limits and also provided protections for employees who use marijuana outside of work. What specifically is now legal with respect to marijuana and cannabis use in New York is shown on this slide. I'm not going to go through it all in careful detail, but it includes possessing or even purchasing marijuana, although it's still not legal to sell marijuana in New York, other than medical marijuana, which is a different issue in most respects. Transferring it. So, in other words, you could give it as a gift, though you can't sell it. There have been some discussions about what happens if you basically throw in marijuana as a freebie in another sale. So you sell somebody, for example, paraphernalia used to consume cannabis in some form, and with the purchase, you then include some actual consumable cannabis or marijuana in whatever form. That is not legal currently either. That's just a way of selling marijuana without appearing to be selling marijuana, but you still are. Anyway, you can also use, smoke, ingest, or consume cannabis, and you can help other people do any of these things as long as everybody involved is 21 years of age or older. None of this is legal for people who are 21, under 21. Why is all of that relevant? Because now the labor law says that employees are protected in work for their off-duty use of lawful consumable products. So basically, if they do the things that they're allowed to do under the marijuana law that we kind of just discussed, then that can't be held against them at work. There are some parameters. The use is protected if it's outside of work hours or off the employer's premises and without the use of the employer's equipment or property. So if you have somebody who is at work, they don't have the right to use marijuana. If they are technically off of work, but still on site, facility owned or controlled by the employer, then you could still prohibit them from using cannabis in any form. And if for whatever reason the employee has company property or equipment offsite outside of work hours, they cannot consume marijuana while they are using in some way that equipment or property. The law doesn't allow anyone to use marijuana in a car, for example. So it's not, this particular provision doesn't exactly kick in just because somebody has a company car. I mean, you can certainly tell them they can't use marijuana in a company car at any time, but the reality is the law doesn't allow them to use it in the car at any time anyway. Okay, so there are some exceptions basically that are in two different categories. One is that if the use it does somehow implicate state or federal law that the employer has to act on, then they have the right to act consistent with that state or federal law. We'll get to that in a minute in at least one respect. The other big exception is that employers do not have to allow their employees to be impaired by the use of cannabis, such as including marijuana, while they are working. The big problem there is, what does it mean to be impaired by cannabis or marijuana? So the law talks about impairment in the following way. It is defined to mean that the employee manifests specific articulable symptoms that either decrease or lessen the employee's performance of the duties or tasks of the employee's job position, or interfere with an employer's obligations to provide a safe and healthy workplace free from recognized hazards as required by state and federal occupational safety and health law. For the most part, The first of those requirements is going to be the one that is going to apply. It would be the concern that it would decrease or lessen their performance. It's hard to imagine, I think, a way that somebody could use marijuana in a way that would cause safety and health concerns without decreasing or lessening their performance. But I suppose if theoretically their performance could be improved while they're nonetheless being more dangerous, then you'd be able to rely on that second prong. But the only reason I'm saying that is it seems that the new guidance from the Department of Labor focuses more on what shows that performance was decreased, and basically assuming that the safety issue itself is also another form of lessened performance. So we did get kind of unexpectedly guidance from the New York State Department of Labor in the form of frequently asked questions on cannabis and the workplace. Just in case I didn't mention it, cannabis is just the term that the law has chosen to use to include marijuana in any and all forms. I guess as defined, cannabis is more broadly construed than marijuana in some technical respect. I think most people are more likely or have been more likely in the past to talk about marijuana than cannabis, but perhaps that'll change as, for whatever reason, more cannabis products might be marketed than specifically wanting to call it marijuana or any of the other street names for what everyone understands to be marijuana or cannabis. The Department of Labor's frequently asked questions address a number of issues that are not really that surprising. So I'm not going to spend too much time on that. I mean, they restate some of the requirements of the law, for example, in just question and answer format. For one of the questions is legal or is illegal cannabis use protected? No, illegal cannabis use is not protected. As I said, if someone is under 21 or they're using it in a car, then it's illegal anyway. So the law doesn't protect employees to use cannabis illegally, obviously. But it does talk about some aspects of workplace use that might be relevant. For example, the frequently asked questions get into the issue of, well, can we as employers allow our employees to use cannabis while they're working? And basically, the Department of Labor confirms that yes, there's nothing in state law generally that prohibits employers from allowing employees to use cannabis in some form while they're working. May not be able to smoke it depending on where you are. If you're in a building, for example, that you're not allowed to smoke in, then you're not going to be able to smoke it, but you could use other forms of cannabis. So, on that hand, while you don't have to allow employees to do it while working, you can allow them to if you choose to, which you can imagine some companies, maybe in the cannabis and marijuana field, might decide that it makes sense for them to allow their employees to use the products while they're at work. The other interesting aspect I thought of this is just a couple of clarifications of what it means to be basically at work. And it does include being on call. So, an employee who is on call and may need to come in can be expected to be not using cannabis or marijuana at that time. But the bigger aspects of the frequently asked question are in these last two categories, impairment and drug testing. So we're going to go into more detail on what the Department of Labor has to say about that. So with respect to the impairment question, the frequently asked questions have decided that it will be helpful to tell us that specific articulable symptoms means objectively observable indications. So I guess that pretty much clears that up. Although to me, I'm not really sure what the difference between the words specific articulable symptoms and objectively observable indications are. Uh, just big words that mean whatever somebody wants them to mean, I think. There's a little bit more detail discussed in the frequently asked questions. Um, for one thing, the Department of Labor warns that such symptoms could alternatively indicate a protected disability. So, one example they specifically give is operation of heavy machinery in an unsafe and reckless manner, noting that yes, perhaps someone who is being impaired by marijuana might operate heavy machinery in an unsafe and reckless manner. However, it is possible that someone is operating heavy machinery in an unsafe and reckless manner for some other medical reason, such as that a condition is flaring up, whether it be arthritis or chronic pain or uh, other conditions that you might imagine. Obviously, if someone had a stroke or seizure while operating heavy machinery, that would indicate a medical problem that might have nothing to do with consuming or being impaired by marijuana. Frankly, all of the guidance isn't terribly helpful, because it basically just tells us you have to look for these hard to define terms that don't really mean anything as far as what exactly the cause is, and warn that you shouldn't be um, obviously discriminating against people for signs of disabilities. Now, in the case of operating heavy machinery in an unsafe and reckless manner, it really doesn't matter if that's caused by disability or cannabis in the first instance. Either way, you're going to have a right to try to figure out what the cause was. But other potential observable indications, I suppose, that don't pose any immediate risk to anyone, might create issues for you if you start asking the person, why are you walking with a limp, for example. Again, I don't think walking with a limp is necessarily going to be a likely indication of marijuana impairment, but whatever it might be, not making good eye contact, again, is that an issue because someone's having a migraine headache or because they're using marijuana? So I'm just concerned that unfortunately the frequently asked questions haven't helped us very much. And if anything, they may specifically rule out some of the symptoms that people have historically relied on as evidence of marijuana usage, because they point out that, according to the Department of Labor anyway, observable signs of cannabis use that don't indicate impairment can't be relied on as specific articulable symptoms of impairment. Um, a likely example of that would be a situation where someone smells of marijuana. The frequently asked questions note that just having the odor of cannabis or marijuana is not a specific articulable symptom of impairment, because obviously now the law allows people to use marijuana. They could have smoked marijuana a couple of days ago in their home or apartment where the clothes that they're now wearing to work are stored. So that would not be indication of impairment. They don't address in this guidance things like bloodshot eyes, but they, with their wording, kind of imply the question of whether that really indicates impairment or just possibly indicates recent use. And there's always going to be a debate of how recent of marijuana use indicates that someone is actually impaired. So I really think this is a nightmare. I think it's very unfortunate the Department of Labor used operation of heavy machinery in an unsafe and reckless manner as their only express example of specific articulable symptoms of impairment. Um, there are probably going to be many situations where it would be better to find out that someone is impaired by marijuana before they start operating the heavy machinery in an unsafe and reckless manner. But at this point, that is the guidance that we have from the Department of Labor on the issue. Now, on the topic of drug testing, the Department of Labor has confirmed what I thought was fairly obvious from the law itself, that drug testing itself cannot be used to demonstrate impairment because any drug test for marijuana or other forms of cannabis tend to register positive even if the use was not recent enough to likely cause impairment. The frequently asked questions go even further to specifically state that employers cannot test for cannabis unless an exception to the labor law provisions apply. And mainly the example of a exception there would be the situation where certain drivers have to be drug tested under state or federal law. So motor carrier drivers under federal law have to be tested, meaning people who drive certain commercial vehicles, buses, or airplanes or something like that, as well as big rig delivery trucks. And certain state laws would require some drivers in the state to be drug tested as well. But that is a pretty limited exception for drivers. Not immediately aware of other situations where the law requires someone to be tested for marijuana. But if they did, then you would be allowed to do that. Otherwise, if you're testing for drugs in a pre-employment screening or a during employment situation, whether it be reasonable suspicion, periodic, or random testing, you should not be testing for marijuana. All right, now the kind of last big New York specific topic that I want to catch everybody up on is the HERO Act. The HERO Act actually has two components that, for most purposes, don't have anything to do with each other, although I'm fairly sure the legislature didn't realize that when they passed the HERO Act, surprisingly enough. But the HERO Act introduces two new sections to the New York labor law. And the first section is the one that required private employers to have airborne infectious disease exposure prevention plans, which as of Labor Day had to actually take effect with respect to COVID-19. The original activation was in effect through the end of September. At the end of September, that was extended through the end of October. So as of now, you have to have your airborne infectious disease exposure prevention plans active through at least Halloween, although it's quite likely that sometime later this week, the Commissioner of Health will then again extend the activation period at least through, I would say, the end of November, possibly through the end of the year. But technically, that remains to be seen. So I wouldn't get comfortable that you're going to be able to forget about your airborne infectious disease exposure prevention plan anytime soon. But you should watch just to make sure that nothing changes on that this week. The airborne infectious disease exposure prevention plan requirement, just to be clear, doesn't apply to public employers, so towns, school districts, villages, counties, etc. It also doesn't apply to employers subject to OSHA regulations. And for this purpose, the Department of Labor has made it clear that the healthcare regulations that are in effect from OSHA meet that uh, criteria. So hospitals and nursing homes are not subject to the Airborne Infectious Disease Exposure Prevention Plan at this time because they are subject to existing OSHA regulations. That raises a question that we'll come back to later. If and when the federal OSHA vaccine mandate takes effect for employers with 100 or more employees, will that then kick out or displace the Airborne Infectious Disease Exposure Prevention Plan for all such employers? And I'm not sure there's a clear answer on that at this point. I suppose you could also raise the question for federal contractors, but the answer there is, while, as we'll discuss, there is a vaccine mandate coming for federal contractors, it's not an OSHA mandate, and the New York HERO Act provisions are specific to OSHA. The bigger topic I want to discuss from the HERO Act is the second part of the HERO Act, which created a new requirement that employers have workplace safety committees. This provision doesn't take effect until November 1st. However, November 1st is now less than a week away. So while we've been able to kick the can down the road on workplace safety committees for the past few months, worrying about the airborne infectious disease exposure prevention plans, now is the day of reckoning, or at least it is very nearly upon us. So there's a new section of New York Labor Law 27D that applies to private employers with at least 10 employees in New York. So again, if you're a public employer, this doesn't apply to you. If you happen to have less than 10 employees working in New York, then you're not currently going to be subject to this workplace safety committee requirement, but it's something to keep in mind. If you're at a number under 10, once you hit 10 employees, then you would then become subject to this. The law says that covered employers must permit employees to establish and administer a joint labor management workplace safety committee. The law also says that there cannot be more than one workplace safety committee per work site. There's some ambiguity in some of the terms because, unfortunately, as I mentioned, I don't think the legislature knew what it was doing. And when they wrote the HERO Act, they defined a lot of terms regarding the airborne infectious disease exposure prevention plan obligations that they likely intended the definitions to also apply to the workplace safety committee provisions, but because they're in two separate sections of the law and based on some pretty clear statutory interpretation principles, those definitions don't actually apply to the workplace safety committee requirements. So we don't really know what exactly a work site means, but it does also say that there might be more than one workplace safety committee based on geographical differences. So if you have more than one facility, then it is possible that you could have more than one workplace safety committee. It's not entirely clear at this point whether you're obligated to have more than one workplace safety committee. But that's just one of the numerous questions that are virtually impossible to answer at this point in time until the Department of Labor gives us more guidance, which they have said they will do, but they have not done yet. So we're going to do the best we can to tell you what it looks like the law requires. And the biggest question is really, how do we form these workplace safety committees? The law tells us that it's comprised of both employee and employer designees, and at least 2/3 of the designees have to be non-supervisory. Now, among the many headaches that the law creates, saying at least 2/3 non-supervisory makes it pretty much open-ended, that it could be 99% non-supervisory, or it could be 66.6% non-supervisory, and who gets to decide which it is an open question. The employee designees are selected by and among non-supervisory employees. Okay, so there's clearly an intended distinction between supervisory and non-supervisory employees. Again, unfortunately, the legislature defined those terms, primarily non-supervisory employee and supervisory employee, in the Airborne Infectious Disease Exposure Prevention Plan section of the HERO Act, but that definition doesn't technically apply to the Workplace Safety Committee section. So it's reasonably likely that the Department of Labor may try to use the other definition for Workplace Safety Committee purposes, and they might have the authority to do that, but the law itself doesn't actually say or require that as written. So even assuming we know who supervisory and non-supervisory employees are, all our problems are not yet solved. We do know that the committee has to be co-chaired by a representative of the employer and of non-supervisory employees. Presumably the representative of the employee then is a supervisory employee, but it doesn't exactly say that. The representative, the co-chair representative of the non-supervisory employees presumably means among the employee designees, at least 2/3 of whom are non-supervised. So again, I'm trying to make the point that it's kind of unclear how all of this is going to work. And so far, we have no further guidance on who makes some of these decisions and classifies employees and distinguishes supervisory, non-supervisory employees, etc. Another point that the law does establish, although all it probably does is creates more hassle than it's intended to, is the law says where there is a collective bargaining agreement in place, the union shall be responsible for the selection of employees to serve as members of the committee. Okay, well, let's assume we might think we know what this means. Let me show you quickly how many problems it could raise. First of all, it says the union is responsible for selection of employees to serve as members of the committee. It doesn't say anything about supervisory and non-supervisory employees. So theoretically, you could read this language to say the union gets to pick not only the non-supervisory members of the committee, but also the employer or supervisory employees. I don't think that really makes any sense. There is talk about employer designees. If the union is picking them, they're not really employer designees, but there again could be some issues on the margin there. The bigger problem to me is what happens when the union doesn't represent all non-supervisory employees. The union is responsible for selection of employees. Well, what if there are more than one union? How do they fight over that? Do you have to have a separate workplace safety committee for each union? Well, probably not, because the law does say one per work site. Anyway, so again, room for problems if you have a union. Not that anybody's trying to create problems, just that we have questions that are not answered, and reasonable people could disagree over the answers. Once we have the committee, there's a list of actions that the committee can take. I'm not going to read through all of this. Basically, they get to review different policies and plans and raise concerns. They get to have monthly or quarterly meetings, but it's not really clear what the employer's obligation is once the committee raises issues or reviews policies. Does the employer have to do something about it? Does the employer even have to um, take it seriously? It does say the employer must respond, but what does respond mean? And there's a question of what happens once the committee reviews a policy. Again, does the employer have to respond if they get feedback from the committee? Do they have to negotiate over changes to the policy? Can they just throw the feedback in the garbage? Uh, Unfortunately, the law doesn't answer these questions. It does provide employee protections. And clearly, the whole purpose of the law is to protect employees. So there's ample language aimed at that. No employer shall interfere with the selection of employees who shall serve on such committee or who serve as the workplace safety committee designee or with such employees' performance of the duties authorized under the section. Again, this could be written much better. It says you can't interfere with the selection of employees. Well, again, presumably that means the non-supervisory employees, but it just says employees, which technically includes, by definition, the supervisory employees. The other provision that provides direct employee protections is arguably repetitive of the first. It says any employee who participates in the activities or establishment of a workplace safety committee shall not be subject to retaliation for any actions taken pursuant to their participation. And there are references to statutory penalties for employers who violate these provisions. So let me come to where we are, and I know this probably answers a couple of the questions that are popping up. The Department of Labor issued a frequently asked question on the New York HERO Act in September. That frequently asked question document originally suggested that covered employers would be required to establish workplace safety committees. But a week or so later, the Department of Labor changed its guidance document to now not refer generally to the New York HERO Act, but to address the New York HERO Act Section 1, which is the Airborne Infectious Disease Exposure Prevention Plan section and provisions of the HERO Act. The current guidance only barely addresses workplace safety committees, but does now use the word allow, saying that employers must allow their employees to form a workplace safety committee. It then goes on to specifically state that the Department of Labor will provide guidance on workplace safety committees before November 1st. It is October 26th. As far as I know, that guidance is not available publicly anywhere yet. Hopefully it is mostly written, because if they do what they said they're going to do, they have to get it out by Sunday. I have seen in the past before a certain date for the Department of Labor could either mean 11:59 the day before, 11:59 p.m. the day before, or on that date. But I do suspect they will probably have it out this week. I'm just not optimistic they'll have it out before Friday, and I'm also not optimistic that even having it out as early as today is a reasonable amount of time to digest it and be prepared to apply it starting next week. All that being said, hopefully it will be out soon enough that if you have employees coming forward adamant about starting their workplace safety committee next week, you can at least put them off until you have a chance to reasonably review any guidance that the Department of Labor will come out with, especially if you have an existing union or employees who are being difficult about how you're going to prepare these committees and what they're going to be able to do. I recommend conferring with your labor lawyer to apply that guidance once it comes out. But in the meantime, if you want to see what guidance there is, the place that you should look is this Department of Labor webpage. on the New York Hero Act, and the easiest way to find it, in my experience, is just to go to Google and type in New York Hero Act, and it will be the first link that comes up. But that is where they are likely to post any additional guidance on the workplace safety committees. So I would try that first if you are like me and want to refresh it on the hour or less, or more frequently because you need this information as soon as it is available. But one way or the other, once more information is made available from the Department of Labor, I will follow up to try to make that information available, depending on how the information is presented and how detailed it is. I may schedule another webinar just to discuss that topic. We'll probably also have written guidance available as well to let you know that this new information is out there, and you should at least start to familiarize yourself with it as you prepare to meet this new requirement as early as next week. Okay, so we don't have that much time left for the federal section of this presentation, but I think we have enough because there's really just an update on a couple of topics that we need to kind of run through. They basically all stem or relate to the president's action plan announced last month on basically how he's going to get everybody in the country vaccinated. And in certain respects, this is going to be done in connection with employment. So the idea is that all employers with 100 or more employees must require vaccination or weekly testing as an alternative. Obviously, this is for COVID-19. Just to be clear, that 100 or more employees would certainly include private employers. It might include public employers, including in New York. It depends on what the states decide to do, because OSHA doesn't directly apply to public employees, but the states, including New York, typically adopt standards that are at least as protective of any OSHA standards. So first of all, we don't have the OSHA standard for private employers yet, much less information on what the state will do, but it certainly wouldn't be surprising when the OSHA standard takes effect that New York would also apply that in the public sector. The president also called for mandatory vaccination for healthcare workers, which we already have in place in New York anyway, mandatory vaccination for federal workers and contractors. I don't think any of you work for the federal government, so the focus here is really on federal contractors, which some of your organizations probably are. So I'm going to go into a little more detail on what has developed in that area. And the president also called for paid time off for employees to get vaccinated. Again, in New York, we already have a law that requires that, so it's less relevant, but that is likely going to be attempted as part of whatever OSHA does, although it's pretty questionable whether they have that authority. Let me get to the federal contractor issue, because some of you probably are federal contractors, and also because it is the best guidance we have so far as to what the more generally applicable OSHA rule might look like. So there's an executive order from the president that applies to most federal contractors as opposed to grantees. So if your organization has grants, especially if you're, for example, a nonprofit organization and you get grants from the federal government, that's not enough to trigger any of this. It would have to be a federal contract. However, contract is pretty broadly construed to include, purchase arrangements that might or might not be formally documented in a contract per se. We don't have enough time to go into the details on what might be a federal contract or not, and which organizations may or may not be covered. The important thing to note is that if you've been a federal contractor in the past, you're not automatically going to have to vaccinate going forward. It will only be the case if you get a new contract or extend an existing contract or renew it, etc. Sometime now or in the future. So it could go back as early as if you did this after or effective October 15th of 2021. Depending on the type of the contract, the deadline might be after, I think it's November 15th. But regardless, the idea is it's a contractual provision that the federal government is going to impose, and that's where they get the legal authority to do this. So if you have something coming up with the federal government or as a subcontractor to a contractor with the federal government, you should review whatever you are doing, a new contract, an extension, renewal, etc., to see if there is a requirement for vaccination in that contract. If there is, then the deadline for employees to be vaccinated is December 8th. Of course, if your new contract is not in place before December 8th, then it would be the deadline would become whatever the commencement date of the performance of the contract would be. So if you sign a contract on December 21st, your employees don't necessarily have to be vaccinated then. They just have to be vaccinated by the time that the work will begin under the contract. And there's something that's been created called the Safer Federal Workforce Task Force that is creating these guidelines, and they can continue to modify the requirements during the life of contracts. So once you agree to a new contract, it's going to say something along the lines of basically that you will continue to follow any new requirements of this task force. So things could change, and you're obligated at that point to become aware of any developments and to comply with them. If you are a contractor and you're covered by these requirements, then employees will have to be vaccinated. There is no testing option. It applies to employees of both federal contractors and their subcontractors down to any level unless and until the subcontract is only to provide products. So if the company with the contract with the federal government is doing services for the government, and all you do is sell that company, whatever it is, cleaning supplies, for example, then this isn't going to apply to you. But if you perform services that you come in and work for that contractor on those federal contractors, then you're covered. Which employees are then covered? All employees working in connection with a covered contract or at a covered workplace. So if you are performing a federal contract on your premises, then most likely your entire facility is a covered workplace, and everyone who works there has to be vaccinated, whether they are working on that contract or not. In addition, it's anyone who works in connection with the covered contract, whether they are working in the covered workplace or not. What this primarily means is if you have someone who is working from home, they do not work in a covered workplace. But if they are working from home in connection with the contract, then they also have to be vaccinated, even though they may never come into contact with anyone else because they're at their home. Clearly, this is just a way that the government is requiring as many people as possible to get vaccinated. There are possible accommodations for disability and religious beliefs. So theoretically, your accommodation could be to allow someone to work from home if they can't be vaccinated and work in person. So there is theoretically a way someone could work from home without getting vaccinated, but they would have to have a disability or religious belief that entitles them to that accommodation. The government does not tell contractors which accommodations are required or when accommodations are required. It just says that if an accommodation is required under the disability discrimination laws, then you have to evaluate whether there is a reasonable accommodation that doesn't pose an undue hardship. So again, this is the statement on the OSHA rule that's supposed to be coming out for employers with 100 or more employees. So this would be independent of federal contractors. If you have 100 employees, you may be required to have your employees fully vaccinated or get weekly tests proving that they are negative. We understand the rule was submitted to the White House's Office of Management and Budget on October 12th, so 2 weeks ago. Again, as of the time this presentation started, that had not been approved and finalized from the White House. We don't know if and when it will be. What we do know is that there are plans in place for litigation to block the enforcement of any such rule. Don't know how those cases will come, but there are reasons to believe that the OSHA rule could be blocked as exceeding the authority of the agency and the federal government. But there's no guarantee that will be the outcome. There is recent news that business groups are strenuously seeking to delay in implementation of any such vaccine mandate rule until 2022. Specifically, what they're trying to do is push it off beyond the holiday season, noting that there's already a workforce shortage and expected difficulty in getting employees in place for the holiday shopping season. So they don't want this vaccine mandate or even weekly testing requirement to further impair their ability to have workers. And I think that's a consideration that the White House may take seriously. If nothing else, they have to allow some lead time for the effective date of any requirement, and we are running up towards the end of the year. So it is quite possible that whenever the rule actually comes out, the requirement may not take effect until sometime in at least January, but we don't know that yet for sure. Finally, yesterday, the EEOC came out with some updated guidance on religious accommodations to vaccine mandates. So this may apply if there is a federal government requirement or a state government requirement in place for your workforce that they be vaccinated or be tested weekly. However, it could also be just as applicable if you just have voluntarily imposed a vaccine mandate in your workplace. So the three key points the EEOC made yesterday, and then I'll get to questions, are that first of all, the employee or applicant must ask for the accommodation due to a sincerely held religious belief, practice, or observance. So the employer doesn't have to go out and ask whether anybody needs an exception or accommodation. The employee or applicant would have to raise that issue. They note that Title VII requires employers to consider requests for religious accommodations, but it does not protect social, political, or economic views or personal preferences of employees who seek exceptions to a COVID-19 vaccination requirement. Unfortunately, as the EEOC goes on to acknowledge, it's not always clear what the line is between a personal, political, or social view and a religious view. And the EEOC and the courts have always been fairly deferential to employees who claim they have religious beliefs. It's pretty hard to disprove those beliefs, but there is more discussion in the guidance that I don't have time to read in detail right now that talks about circumstances where maybe you could question the validity of the belief if, for example, it's inconsistent with somebody's recent prior activities, etc. If they, flat out told you they don't have any religious qualms about getting the vaccine, they just don't want to take it. And then the next day they come in and say, oh, actually, it is my religious belief. That may be grounds to question the validity of the belief and deny an accommodation. But on the other hand, the EEOC allows that it is possible for people's beliefs to change over time, and that has to be weighed as well. So not an automatic out, but it is something to consider. And then the employer can demonstrate undue hardship and then not be required to accommodate an employee's request for religious accommodation. Of course, this is a case by case analysis. The EEOC doesn't tell us what is or isn't an undue hardship. It just says you have to consider all the circumstances, decide whether there is a reasonable accommodation, and whether any such accommodation would be an undue hardship in your circumstances. For the most part, what it looks to me that this document is doing is trying, on one hand, to come out and say, look, we don't want people to get religious accommodations to the vaccine mandate without actually warranting the accommodation. Frankly, I think the federal government's position is we would certainly rather everybody get vaccinated. But on the other hand, they acknowledge that the law is the law and it does provide for the right to reasonable accommodations for religious beliefs. So you have to work your way through that law somehow. And I think the EOC says at the end of the day, in close calls, we don't really know what the right answer is. Do your best, and if we have to litigate it later, then I guess we will, which is not a great situation for employers to be in. But as with so much more involving COVID and just involving the workplace in general these days, is not a surprising position to be in. Again, there's things that are going to continue to get updated. The fastest way we can let people know about what we are aware of is through our LinkedIn page. So follow Horton Law on LinkedIn. I will try to send out information or have more webinars as warranted when major develops continue to occur, as we all know they will. So stay tuned for that as well. I do want to get to questions. I know there's a number of questions in queue, so I'm going to start going back through those. Please get your questions in. In just a moment, I'm going to put the link up to the slides. You will get that by email as well tomorrow if you want to wait for that information. Just a reminder, I don't think there's any real problem here, but as I'm answering these questions, don't ask a question in such a way that it's so detailed that people know who your business is when I try to answer it, because we don't have attorney-client privilege in this discussion. If you have a situation that requires confidentiality in the attorney-client privilege, then contact me or your attorney directly to have that discussed. There's a question on marijuana. Can an employer request testing if the employee shows signs of intoxication and is injured during work hours? I think the Department of Labor has said no, and that seems to be the case. I mean, the only argument would be if you can somehow show that the presence of cannabis in the person's body has somehow exacerbated the injury. It's just not going to be considered evidence of impairment. That's not going to be relevant to that issue under New York law. And as explained by the Department of Labor, they are basically saying no marijuana testing in New York unless the state or federal government expressly requires that such testing take place. There was a question about a specific New York City law, and I'm sorry, we don't have time to be focused on some of the specific New York City requirements in this presentation. So I'm not going to get to that right now. Here's a question on minimum wage. If an employee is working remotely in another state, but the company is in New York, which is the prevailing minimum salary, hourly, and exempt I guess threshold is going to be the question. So these questions get tricky. I mean, it certainly happens, right? And different states can actually answer the question differently. I know California is fairly aggressive, at least in theory, about if somebody is working physically in California, even if just for a day, and if they're traveling for work or whatever, they are then subject to all of the state employment law requirements for that day or those days. I think for the most part, as long as people are focusing on where the person primarily works, they're going to be okay. But if your office is based in New York State and you have an employee who lives in another state and works almost all of their time in that state, then they most likely have to be paid in accordance with the requirements of that state, not New York. But it could be a case by case inquiry depending on how often they are in various states. The paid sick leave law in New York does specifically address the question that if somebody primarily works in another state but comes into New York to work, then they accrue sick leave based on the time they are physically present and working in New York State. So they have started to address it in that respect. But for the most part, as far as minimum wage and overtime thresholds, the typical practice is, and usually it's fine just to focus on where the person works most of the time. I'm trying to interpret this question. If I don't get it right, you can follow up. Something about non-DOT workers that are randomly test positive. So if they're not a transportation employee or some other employee subject to a law that requires testing for marijuana, then you can't test for marijuana. You can randomly test for other drugs, but your panel needs to no longer include cannabis. If for some reason you nonetheless test for marijuana and they're tested positive, then it doesn't mean anything because they have the right to use marijuana. There's a kind of a follow-up question on marijuana and being injured and the workers' comp consequences. I mean, again, in New York State now, the law is that people are allowed to use marijuana, and the policy is clear that the policy, I mean, the position of the state as a legal matter is that drug testing isn't going to show you whether um, the presence of cannabis contributed to an injury. So I'm not aware of any situation other than the transportation type of legal requirements to test for marijuana where the state says it's okay to have employees tested for marijuana. I mean, maybe somebody will come up with something at some point, but as of right now, I'm not aware of anything that would justify it other than somebody taking a position at odds with what the Department of Labor says on the theory that they believe they know better and can challenge the validity of the test as to whether it proves impairment or not. Question: do you have to register the state workplace safety committee somewhere? There's nothing so far that says you have to. I seriously doubt the Department of Labor is going to create that requirement in any regulations. Generally, they don't want people reporting stuff to them that you don't have to report to them because they already have enough to do, including coming up with guidelines for what I'm sure they consider a stupid workplace safety committee law. Apologize for editorializing, but it's become pretty clear to me the Department of Labor is disillusioned with all of the requirements that the legislature keeps throwing on them without thinking through any of the consequences and basically just telling the Department of Labor, we have no idea what we want, but we just know we want to create something to keep employees safe. We'll throw something in the statutes, and then you go figure out how to enforce it. I don't think the Department of Labor, or at least the rank and file in the Department of Labor, are thrilled about that. They're doing their best to get through it. But again, I can't see them coming up with on their own any requirement to register something with them. Question on the Workplace Safety Committee: should these provisions be made known to the entire staff? At the moment, I would not recommend that anyone go out of their way to make employees aware of the Workplace Safety Committee, because you're not going to know the answers as to how they form the Workplace Safety Committee. And at the moment, it doesn't sound like there's an obligation to do anything unless an employee comes forward and says they want a Workplace Safety Committee. So for now, at least, I would just hang tight. Next question. Does the language permit employees mean we do not need to have a committee unless it is requested? Yes, that seems to now be the position of the Department of Labor. I think it's the right reading of the statute. The Department of Labor did have something in its original HERO Act frequently asked question that suggested otherwise, but they clearly revised that and took it out. And now it's pretty clear as of now that at least one employee is going to have to come forward and say, we want a Workplace Safety Committee. What happens if only one employee wants a Workplace Safety Committee? We don't know yet. So again, it's a real headache for the Department of Labor to try to figure out what to do with this. I mean, I guess it's their job and they'll figure it out, but it's basically putting them in a no-win position. There's going to be litigation at some point to challenge these Workplace Safety Committees as well for various reasons. The union implications are complicated and implicate federal law. So yeah, you don't need to go out of your way, I would say, at this point to create one by November 1st. Even if somebody asks for it, I think you have some time to say, wait, we got to figure out what we're actually supposed to do. But if somebody starting November 1st says, where's our Workplace Safety Committee? I wouldn't just slam the door on them. Obviously, let them know that we're working on it and you'll get back to them. Question: if we provide employees with an exemption for the vaccine, would we need to test those individuals weekly? This, generally speaking, depends on whether you're doing the vaccine requirement because you want to as company policy, or you're required to do it by some state or federal legal authority. If you're just doing it voluntarily, saying for our company we want to have a vaccine mandate, then you have to consider accommodation requests, and then you basically have to decide what you think is a reasonable accommodation that doesn't pose an undue hardship for your company and for that employee. Well, undue hardship for your company, a reasonable accommodation for that employee. So you could decide that weekly negative testing is a reasonable accommodation and reasonable alternative, but there's nothing expressly saying you have to do that. If you were an employee subject to the anticipated OSHA rule with 100 or more employees, then we don't know what the wording exactly is going to say, but we know that they're putting weekly testing in as an alternative to vaccination in the first place. So that might be relevant. The other piece of that issue to keep in mind is that you may have to accommodate the weekly testing requirement as well. Somebody may say that their religious beliefs prevent them from getting tested weekly. I apologize. I just put up the link to the slides. Nobody reminded me. You could have done that. I appreciate your patience. So that is up now. If anybody had to drop off, they will get those sent to them. So again, my apologies, but those will be available. I'm not trying to hide anything. there. But yeah, keep in mind that whatever the requirement is, there could be a religious reason why somebody says they can't be required to do it. So, whether it's vaccination or weekly testing, even wearing masks. So, the federal contractor guidance acknowledges that some employees might even need an accommodation to a mask requirement. Obviously, these days, a big question is whether working from home is a reasonable accommodation, and different employers are deciding that issue differently, and potentially it could be a different answer based on different positions that employees hold. Factory workers are not likely to be able to work from home, but certain administrative employees may be able to. That then raises the question of, do we have to tolerate anyone working from home if we want our employees working in the office? And this is a new world that we live in, and we don't really know what the uh, discrimination agencies and the courts are going to say about that ultimately. So, unfortunately, we're in somewhat uncharted territory here. I can say the EEOC has filed a lawsuit, um, not in New York, but elsewhere in the country, on the claim that working from home should have been allowed as a reasonable accommodation. But again, there's no evidence that the EEOC takes that position uniformly across the board, but just in this particular case, they felt that the circumstances warranted that the employee should have been allowed to work from home as an accommodation. Related to COVID, I don't think it was a vaccine requirement, but just in general. All right, I think I've gotten through all of the questions that I've seen. I have now made the slides available. I appreciate everyone for taking the time. We had very good turnout for the webinar and very good questions. Hopefully I had good answers to most of them. If there are any more questions that you're still thinking about or trying to type out, go ahead and enter something so I know you're asking a question. Yep, here's a question. Did I hear that safety committees are not necessary unless the employees want it? As of now, that seems to be the Department of Labor's position. I had a presentation last month where I talked about the guidance that the Department of Labor had out at that point. I will get it. The Department of Labor, as of somewhere around September 21st or 22nd, did specifically say that the law requires employers with 10 or more employees to establish and administer a joint labor management workplace safety committee to ensure workers play an integral role in worksite safety and can raise safety and health concerns. This requirement goes into effect on November 1st, 2021. However, they have since rescinded that guidance, and the new guidance uses the word allow. So it seems pretty clear the Department of Labor has realized they overstepped and are now taking the position that you just have to allow employees to form a safety committee if they want to. However, that's probably going to be a pretty light threshold, such that if just one employee wants to form a workplace safety committee, that may trigger the obligation for the work site overall. And I mean, of course, legally, employers could not do anything to discourage their employees from forming a workplace safety committee. So, what exactly that means, could you flat out say, I'm going to fire you if you form a workplace safety committee? Certainly not. Could you say, we don't really think we need a workplace safety committee here, but we'll form one if you really want us to? Possibly. But, again, we don't have all the guidance that we're supposed to have before Monday of next week, and hopefully it will answer many unanswered questions. Thanks for that. Any more questions before we sign off? Well, we kept the main presentation to about an hour. These questions have gone a little bit longer. Like I said, I'm always happy to stay on and answer them. So I think we have. If I don't see any other question come here in the next couple seconds, then we'll prepare to log off. But thanks again. You will get an email with the slides, and hopefully you will look for our future webinars. And like I said, there are obviously additional developments even on these topics to come in the relatively near future, and we will do our best to continue to get that information out there. Okay, with that, thanks everyone. I am going to log off and close the webinar.